So, good afternoon to everybody, and let me join all the previous speakers in thanking Francesco for this beautiful venue and all the audience for the patience, although we start late once more. But anyway, I try to do my best in order to make it as short as possible and allow the next session, to come on the stage. Let me also, extend my personal best wishes to Federico Dodato, my usual co-moderator, that for this little injury, is very limited mobility for a few days, so he cannot be with us this year, but he's anxious to be with us next year. So the heading of the session is oil and gas transportation and the environment. So we have in the morning, listen so many distinguished panelists and speakers to speak about oil and gas. And every time we speak about oil and gas, we also consider the liabilities that an oil and gas catastrophe can cause, and inevitably we think to the human factor, we think to the environment, and we think how we can tackle and limit the consequence of a big casualty out of the oil and gas and transportation. That, of course, it's a vital and core section of the industry that we cannot avoid. So the first speech today, actually, our keynote speaker is Mr. Mans Jacobsson. We are used to listen to this gentleman since quite a few years now. The topic will be on the Prestige. We all know that the Prestige is a vessel which sank in November 2002, actually 3 years after the Erika, and basically has been one of the two casualties that has changed dramatically the profile of shipping worldwide, and basically give a rise to the modernization of the world fleet and to the very young tonnage that we are all facing today. His speech will be on the judgment of the Spanish Supreme Court of Cassation in the Prestige case. Does the judgment respect international treaties? I remember to everybody that Mans has been CEO of the oil compensation, of the Oil Pollution Compensation Fund between 1985 and 2006, and since he retired, he is working as a lecturer and consultant in maritime and environmental issues. The floor is to Mans for his 20 minutes keynote speech.
Thank you, Mr. Chairman. I'm very pleased to be here again at this conference, and looking around, I see a lot of faces I know since previous years. It's quite obvious that Francesco has no difficulty in convincing us on coming back. And also, I'm amazed. No, I'm not amazed. I'm actually just noting that Francesco has once more managed to get a venue for us, which is a living testimony of the rich cultural and historical heritage that Naples has to give us all. Now, sitting in front of you is one of these useless lawyers, as Mr. Grimaldo referred to this morning. And that reminds me what my son said when he left high school. He said, "Dad, I'm sorry, but I don't want to study law. I want to do something useful." Whether what I'm going to say today is of any use, of course, I leave that to you. Some of you may remember that 2 years ago at this very conference, I made a presentation on the Prestige incident in general terms. And they said it's superfluous coming back to that. But since these 2 years has taken place an enormous development because of the judgment by the Spanish Supreme Court in January this year. And these judgments have led to a very lively discussion on a number of important questions of substance and of procedure. And it has actually been suggested that the judgment on several points does not respect the treaty obligations of the Kingdom of Spain. And this is, of course, a very serious matter. I know it's quite serious to go into criticism of the Supreme Court, but I will nevertheless try to do it in diplomatic terms. With all my due respect for the Spanish legal system, and in particular the Supreme Court. My presentation will be limited to dealing with treaty law issues. I'm not going to discuss problems that lie entirely in the field of Spanish domestic law. A little caveat, when the incident occurred, I was director of the International Oil Pollution Compensation Fund, and for that reason I was responsible for handling that case for 4 years, 2002 to 2006. I want to emphasize that what I say today does not in any way represent the position of the funds, nor of my successor, the actual director. They are purely my own views and analysis. The facts of this case, I think, is pretty well known. In November 2002, the tanker Prestige got into difficulties and broke up and sank to 3,800 meters, some 260 kilometers in the Atlantic west of Vigo. The ship had been carrying some 93,000 tons, 77,000 tons of heavy fuel oil, and it's estimated that some 63,000 tons escaped. The spill had a significant impact on fishing, tourism, and mariculture in France and Spain, mostly in Spain. Major cleanup operations were carried out in these countries, and there were also some cleanup operations carried out in Portuguese waters. The conventions here that are applied are the 1992 Civil Liability Convention and the 1992 Fund Convention, and Mr. Poulsen referred to them earlier today. As regards the civil claims for compensation, there were a very large number of claims submitted to the International Fund of 1992 and to the shipowners, P&I insurer, the London Club, and I think there is actually a representative of the London Club in the room here today. Among these claims were claims from the Spanish and French governments and also a claim from the Portuguese government. Many of these claims have been agreed out of court, but a large number of them, several thousand, have been submitted for dealing with the courts in Spain and to some extent in France. Let us first look at the criminal proceedings in Spain. After lengthy investigations into the cause of the incident in the Spanish criminal courts, the prosecutor decided to raise prosecution against 3 persons: the master of the Prestige, the chief engineer of the vessel, and a person, a civil servant, who had been involved in a very controversial decision not to allow the ship into a place of refuge in Spain. As in many other European countries, under Spanish law, civil claims, that is compensation claims, may be submitted in criminal proceedings. And the criminal court will then decide not only on the criminal law issues, but also on the compensation issues. Some 2,500 claimants brought action in the criminal court in Spain, including the Spanish and French governments. The P&I insurer, the London Club, chose not to participate at all in the criminal proceedings. The club argued that it had fulfilled its obligations under the Civil Liability Convention by depositing in cash the limitation fund of 22 million euros in the Spanish court, and pointed out that under the insurance policy for insurance over and above the limitation amount, disputes should be settled by arbitration in London and under English law. The fund, on the other hand, was a party to the proceeding because it has strict liability under the Fund Convention and did participate in both the criminal court and later in the Supreme Court to defend proper application of the applicable conventions. The criminal court in La Coruña, the first instance court, rendered its judgment in November 2013. The court found that the master, the chief engineer, and the civil servants are referred to were not criminally liable for damage to the environment, as the prosecutor had argued. The court said that the structural failure that resulted in the breakup of the vessel was due to defective maintenance of the vessel, but the court continued to say that the master and the crew were not aware of this and could not have been aware of the structural condition of the vessel, since they were not visible and all of the vessel's required documents were in order. And finally, the court said that there was no sign, no evidence of any risky navigation on the part of the master or the chief engineer. But the master was sentenced to 9 months prison for disobeying the Spanish authorities during the time of the crisis, but that was not damage to the environment that was at stake. Now, what did then the criminal court do with the civil claims? Well, in Spain, a criminal court can only take decisions on civil liabilities if there is a criminal act causing the damage. And if, as the court has said that that was not so, it could not deliver any judgment on all these 2,500 claims that had been submitted in the criminal proceedings. Turning now to the Supreme Court of Cassation. Not surprisingly, the public prosecutor and a number of civil parties, including the Spanish and French government, appealed against the judgment to the Supreme Court of Cassation. Let us take the various issues one by one. First, the criminal liability. In its judgment rendered in January 2016, the Supreme Court confirmed the acquittal of the chief engineer and the civil servants are referred to. On the other hand, the Supreme Court set aside the acquittal of the judgment against the master and found that he was guilty of crime against the environment. Now, it's a very complicated judgment running several hundred pages, but to make it very, very short, the court considered that, first, that the master was responsible for the adequacy of the equipment of the vessel and for the carrying out the proper maintenance and repairs. The court held that he has breached his duty of care with recklessness in relation to importance of the threatened natural resources and the foreseeability of an oil spill. And finally, his disobedience of the Spanish authorities during the crisis increased the risk of an oil spill. The master was given a 2-year prison sentence. Given the time he spent in custody and also his age and other circumstances, it's highly unlikely that he will ever have to serve any time of it, but still he is a convicted criminal, which of course for him is very serious. I'm not going further into that, but I'd just like to mention that the master has argued that the Supreme Court's judgment breached his natural right, fundamental right of defense, and he has lodged an appeal to the Constitutional Court in Spain. Dependent upon the outcome of that appeal, he may bring the matter further to the European Court of Human Rights in Strasbourg. Now, issues of criminal liability, of course, does not fall on the civil liability and fund conventions, but purely domestic Spanish law, and I'm not going to discuss that any further, except I will come back to it in connection with UNCLOS, the United Nations Convention of the Law of the Sea. Turning now to civil liability. First, the civil liability of the master. The Supreme Court found that he was liable for damage arising from the criminal act, and that's more or less automatic in Spanish law. The court considered, and in my view totally rightly, that liability should be established under civil law and pursuant to the provisions of the 1992 Civil Liability and Fund Convention. So far, no problem. But then the Supreme Court also rightly noted there are channeling provisions in the Civil Liability Convention, and I think Mr. Poulsen referred to them this morning, saying more or less that no claim for compensation may be brought against the master personally. But the Supreme Court held that, yes, that is so, but there is also an exception to that in the Convention. So they found that he could not benefit from this protection because the damage was caused by his recklessness and with knowledge that pollution damage would probably result. This holding has been very controversial in the shipping world, and I'm not going to express any opinion on whether this judgment of the Supreme Court was correct or not, because under the Convention it's clearly for the national courts to make the assessment of whether the act of the master is such that it deprives him of the protection of the channeling. So I'm not going to go further into that. Turning now to the civil liability of the ship owner. The Supreme Court held, a little surprisingly, that the ship owner had subsidiary liability for the damage, whereas under the convention, of course, he is the primary liable. Now, it didn't matter very much, but that meant that the court had to consider, under Spanish law, that the liability was because there was responsibility for lack of maintenance and repairs, and that the faulty repairs that caused the fracture of the ship was his liability. Now, of course, under the convention, the courts don't have to do that because there is no fault liability. But so be it, it doesn't really matter on the substantive issue. As you know, under this convention, as in many other liability conventions, the ship owners are normally entitled to limit their liability to an amount which, in the case of the Prestige, was roughly 22 million euros. However, and also as in many other conventions, the ship owner loses the right to limitation if the pollution damage is caused intentionally by the ship owner or recklessly and with knowledge that pollution damage would probably result. And the Supreme Court held here that the ship owner was not entitled to protection, to the benefit of limitation as a result of his recklessness, which consisted in sending the ship on a voyage knowing that there were important structural deficiencies and also with knowledge that pollution damage would probably occur. Now again, I'm not going to have any views on whether or not this assessment was correct, but here it is again for the national courts to make that assessment, whether the actions of the master are so grave that he loses the right limitation, and it has been a very large discussion about that, and this judgment has given rise to great frustration in the shipping community. As Mr. Poulsen said this morning, it was thought that the limitation right under the 92 Convention was pretty unbreakable, but we have now seen in the Erika in France and the Prestige that it may not necessarily be so. So far, relatively simple, isn't it? But let us now go to the more complicated and much more controversial issue, the liability of the P&I insurer. Now first, we have to remember that in order for the ship owner to be allowed to limit his liability, he has to set up which is called a limitation fund by depositing the limitation amount in court or providing the court with a security which the court considers adequate. The insurer is entitled to constitute a limitation fund on the same conditions and with the same effect as if it had been constituted by the ship owner. And in May 2003, the London Club set up the limitation fund in the competent criminal court in Spain by depositing cash the limitation amount of 22 million euros. Now there is one more very important provision in the Convention which the dispute really evolves around, and that is a provision saying that the insurer may avail himself of the right of limitation, even if the ship owner has lost his right of limitation. What did the Supreme Court do of that? Well, the Supreme Court noted this provision and said that there is, of course, in the Convention no acceptance to this. But the Supreme Court still said there is a little more to it than that, and the ship owner must the insurer must actually invoke this right, and by his voluntary absence from the proceedings in the criminal court and the Supreme Court, and by not raising objections in the court to the liability to the victims, then it fell on the insurer to bear the consequences of what the court called this lack of procedural diligence. The court then stated that Spanish law provided expressly that liability was up to insurers' policy limit, and that the Spanish transport law gave victims the right of direct action against the insurer. So notwithstanding this provision in the Convention, which I mentioned, the Spanish court, and it applied then domestic law, criminal law, insurance law, transport law, and Procedure Law, held that the insurer was liable up to the amount of the policy limit, which is $1,000 million. $1,000 million US. And I think that this judgment came as a shock to the shipowning community and especially to the P&I clubs. One point that has been raised is that the argument that the club had not invoked the right of limitation, they say it doesn't stand up to reason, because that is exactly what the club had done by depositing limitation amount for the purpose of benefiting from limitation liability. Now, there's been a very fierce debate about that, and both in the fund governing bodies session in April this year, and notably in the governing bodies meeting last week in London, a fair bitter discussion between, I would say, on the one hand, the delegations of Spain and to some extent France, and the shipowning community, ICS, Intertanko, and the international group of P&I clubs, and all the other insurance interests. Now, when we look at this judgment, I think one has to distinguish between two types of insurance here. We first have the compulsory insurance under the Civil Liability Convention up to the limitation amount. That is governed by the Convention, gives the victims the right of direct action, and limits very strongly the defenses that the insurer may invoke. But then there is the voluntary insurance, that if the shipowner chooses to take out insurance for a higher amount than the limitation amount, which of course most shipowners do, that is not governed by the Convention, it is governed by the policy. And here the policy for all the P&I clubs does not give the victims right of direct action. And it also contains the famous pay-to-be-paid clause, to which I will come back in a moment. And through the club rules, the policy also provides that claimants are to bring disputes to arbitration in London, and they will be governed by English law. Now, in 2012, the London Club brought arbitration proceedings against the French and Spanish governments in London. In a commentary last week, the one delegation, I think it was the French delegation, said it was indecent of the P&I Club to do that while litigation was going on in the Spanish court, and it was frustrating the whole procedure foreseen in the conventions. I'm not expressing any opinion on that. Neither Spain nor France participated in the arbitration proceedings. The arbitration tribunal, they considered in 2013, firstly, that when a third party makes a claim, and again, it's a very long and complicated, but of course I have to simplify it. When a party makes a claim under an insurance policy containing an arbitration clause, then that party becomes a party to the arbitration agreement. So, consequently, the Spanish and French governments were bound by the arbitration clause in the club rules, which are embodied in the policy, to refer all civil claims over and above the limitation amount to arbitration in London. The tribunal also held that under the pay-to-be-paid clause, which forms part of the policy, the club was only obliged to indemnify the shipowner for compensation amounts he had paid to the victims, but it did not give the French and Spanish government right of direct action. And since the shipowner hadn't paid anything to any victims, the club had no obligation to pay the French or Spanish government anything either. And this pay-to-be-paid clause has been subject to the scrutiny of the House of Lords some 30 years ago, and was then considered acceptable. Now, I know that in some countries it has been ruled that the pay-to-be-paid clause is against public order, for example, in the neighboring country of myself, in Norway. The London Club then made an application to the High Court in London to enforce the arbitration awards, and had judgments entered in accordance with the awards. That means that they had no obligation to the Spanish and French governments for any amounts over the limitation amount. Now the Spanish and French government actually did intervene in the High Court proceedings, and of course not surprisingly, opposed the club's request. But in October 2013, the High Court granted the club's application. Spain and France appealed against that judgment, and in April 2015, the appeals were dismissed by the London Court of Appeal. That was before the Supreme Court rendered its judgment. And these judgments were not taken into account by the Supreme Court. Now, in view of and the government did not try to bring the matter before the Supreme Court. Well, a little more. It is, of course, unlikely, in view of this judgment, that the Spanish Supreme Court judgment can be enforced against the club in London. There is one more issue under the Civil Liability Convention, that's those of admissible damages. And there it is for pollution damage, there is a special clause saying that when it comes to damage to the environment, only, apart from loss of profit, only the costs for reasonable measures to reinstate the environment are admissible. And that provision was inserted when the conventions were revised in 1992 to exclude damage, compensation for damage to the ecosystem or other non-economic damage, for example, moral damage. The Supreme Court, nevertheless, said that, well, even claims that are not specifically admitted in the convention can be accepted, and in particular, the court said that moral damage is quite acceptable. Not only the fear and frustration felt because of the Prestige incident, but also the potential fear of Spanish and French citizens that in the future similar cases may occur which will cause them damage. And I submit here that by recognizing these kinds of damage, the Supreme Court has clearly not respected the very clear provisions in the Convention, and the government of member states, including Spain and France, have previously, on a number of occasions, made it clear that this provision does not allow for moral damage. The court did not quantify the damages. They are now subject to the courts. I know that I'm running out of time. I think that also the Spanish Supreme Court did not respect UNCLOS by rendering down a judgment of a prison sentence against the master, although under the UNCLOS that may only be if he has committed a willful act of pollution, which has not even been suggested by the Supreme Court. Now, what can we conclude from that? Well, firstly, as I've said, in some regards, even on disputed points, the non-application of the channeling provision and the depriving the ship owners' right limitation, different views have been expressed, but I don't think one can say that there is any breach of the Convention. But there, in my view, is a breach in three regards: not respecting the right to limitation, accepting moral damages, and not respecting the restrictions under UNCLOS. And there has been, as I said, serious regards from the insurers and ship-owning community. One more point. I think we have now 14 years after the incident, and the Spanish victims have not yet had one single judgment on their claims. They have now submitted for assessment of the damages, and it may take 2, 3, 4, 5 more years before they get a judgment. That cannot be considered an efficient way of dealing with claims of compensation. One can compare that, and they could not bring civil actions because under Spanish law, any civil action based on largely the same facts as the criminal action must be stayed until all criminal proceedings have been brought to an end. This is not the case in France, where victims have very successfully and fairly rapidly got civil claims litigated in parallel with criminal proceedings. So I think that, but the Spanish claimants had no choice here. They couldn't do anything else. But I think a lesson to be learned from that is that states that have these kind of procedures should rethink them so that they can see to it that the system works the way it was intended. That is, that victims, and I'm particularly thinking of the weaker victims, like small businesses, fishermen, mariculture, that they get their compensation, not when they are dead, but when they can still benefit. Thank you.
Thank you, Mans. It was really interesting, and I feel that most of the audience, could not believe that after 14 years there is this, difference of treatment between two European countries like France and Spain. But that's, it's still a long way to go before, we manage to run these things properly.